First, let's welcome Laura Hobbs. She contacted me yesterday and wanted to know if she could be on. And I'm actually kind of glad you did contact me because I think this is kind of an important, it is an important issue here in Shasta County. And I'm sure no matter which way things go, it's going to have implications throughout the state. So I'm glad you're here.
Thank you, and thanks for having me.
What's the issue that you're bringing before the court?
Okay, so there's a number of issues that have to do with the counting of the ballots, but the primary issue is the random alphabetation that should have been done. There are two random alphabets that they do, and one is done at the local level, one is done at the state level. And I'll explain that because it's a little bit confusing, but you can imagine that at the local level, there will be incentive to change the random alphabet. So all the local contests are controlled by the Secretary of State office. So that way, if the Secretary of State rigs that random alphabet draw, she could only affect the election in one of 58 of the counties. Does that make sense? Because it needs to be applied equally to all the counties.
Gotcha.
So it's a bit confusing, but basically all the local races are controlled by the statewide random alphabet draw, and vice versa. So the statewide races on our ballot are controlled by the local alphabet draw.
Okay.
So for the same reason.
I got you. Okay, that makes sense. Yeah.
Okay. So that's the established way of doing it. They admitted that they didn't train their employees correctly, and they didn't follow that California state law, which is California Election Code 13112 and 13113.
I think we may be getting a bit ahead of ourselves. We need to kind of establish, first of all, which office you were running for.
Oh, excuse me,
yeah.
So I ran for the supervisor of District 2. There were 4 candidates on that race. I was listed third on the ballot. Alan Long was listed first on the ballot. And Dan Sloan was second, and Suzanne Barrymore was fourth. So by the random alphabet draw, the letter H was drawn second. I should have been first place because there was no one in the first position with the letter G. So that's not the way it was printed, and they have determined in Gold versus Grubb that there's a primacy effect where the first person listed on the ballot has a 3 to 5% advantage over any of the other candidates, which in District 2 would amount to anywhere between 300 and 500 votes difference. So that's why in this race, it was actually Alan Long got over 50% of the votes, so he avoided a runoff.
A runoff, right?
By only 14 votes. So he avoided a runoff by 14 votes. And
so
the primacy effect is much greater than just 14 votes.
I want to make sure I completely understand this. You're basically saying that if your name had been first, that you believe you would have overcome and gotten that many votes at least.
I believe that I would have been qualified to continue to
or at least have a runoff, right?
Yes.
Right. Okay, that's I think maybe a little bit hard to prove, but I really thought when you first went to court, the judge was actually threatening to just throw the case out, which has not been the case, which is good news for you.
It's very good news. There was some misunderstanding.
How were you able to overcome that?
Well, the judge was believing it was lack of diligence on my part, but it turned out that Alan Long was evading service. So I explained in the declaration of how the sheriff tried to serve him, 3 attempts, left a card. Alan did not respond to their attempt. I also tried privately to hire somebody. They said they would also probably fail for the same reasons. So that elongated it for a whole month. And the judge was upset that it was taking so long. And he also cited some other reasons, such as the fact that he expected me to set the hearing date. But in case law, it specifically states in this type of election contest that the court shall set the date of the hearing within 15 to 20 days. So there were just some clerical issues there that had to be resolved.
So you're suing the elections department, which is basically I guess she's our former elections person, Kathy Darling Allen, and is Joanna Francesca, who is now serving in that capacity, is she named in it too?
She's not named. So the interesting thing about this is that the way the law is written, I have to name Alan Long as the defendant. It's not because he was directly involved in the processing of ballots or anything like that, but also Kathy Allen was named because she was the one who signed the certificate of results. But she has not taken the stand. She claims that her health her doctor has warned her to avoid stressful situation. So Joanna has taken the stand in her place.
Yeah, and basically, if I understand correctly, she kind of admitted that the county did, or that the elections department did exactly what you're alleging they did by not putting your name first on the ballot.
That's correct. And they did it across the board, which is not an excuse. I don't think they did it with malice. There's some legal terms. There's malice and malconduct. Malice implies intent. Malconduct just says they did it incorrectly. Someone was harmed. Therefore, we need remedies. So what we're claiming is it was malconduct on their part.
So what kind of remedy are you asking for?
The remedy is simply to be allowed to go on to a November rematch.
To a runoff
runoff, yep.
And believe me, I'm no expert on election law, but does a Shasta County judge have the authority to grant something like that?
Yes, they do. They have that authority. If they find that an individual was harmed by laws being broken, election laws in this case, then certainly they have the authority to ask me as the plaintiff what remedy I seek, and then I would tell them, my remedy that I prefer is just to go on to a runoff in November.
And so that would be between you and Alan Long then in November, right?
Yes.
All right. Well, this is a very interesting case, and you were telling me before we went on the air about the attorneys that you have hired that are experts in this area.
Yes, it's a very unique type of case, and so an ordinary lawyer would not really work. There's even this judge himself probably has never heard a case like this before.
Yeah, I would think not.
These election contests are rare, so we hired Alexander Haberbush from the Lex Rex Institute. He's a very good constitutional lawyer. He specializes in election law, and I truly believe that if not for him, this case would have been thrown out. He skillfully and artfully argued everything that needed to be argued. I couldn't be more impressed, but it is expensive, and this has been entirely grassroots funded. So I've been grateful for all the contributions people have donated into this case.
How can people help you out if they want to make a donation? I'm sure it's not cheap.
Yeah, well, right now, Lex Rex, there's a donor who's doing matching contributions. So if you donate, whatever amount you donate, it will be matched. And the website there is lexrex.org/donate. And that, again, is lexrex.org/donate. And anything you give will be doubled. So if you give $40, they'll turn it into $80.
All right. How many hearings have you had so far?
Well,
or how many days have you been in court so far?
We've done 3 days.
Yeah.
First was a preliminary just to set the hearing date. And that was the point where he was threatening to dismiss. And then the last week, it was on Tuesday, was the first hearing date. And even, by lunchtime, we still weren't sure if the case was going to be dismissed, but it was looking a lot more hopeful. The judge did do basically a 180 and say that, first of all, he would allow the case to go to trial, but then that even though on Tuesday we were in trial, it was an evidentiary hearing, even at that point we weren't sure which way it was going to go, but he did allow us to present evidence and to question witnesses, and we're quite pleased with that.
Why? On what basis was the judge threatening to throw it out? Were they saying you didn't have enough evidence, or what was the reason?
Well, yes, he was basically saying that it had to do with the fact that when I initially filed, I was filing it by myself, pro se. And
you hadn't served Alan Long either.
And I hadn't served Alan Long, so it wasn't in the procedural format that it should have been. So the court had ordered me on May 2nd to revise that. I hired Alexander Haberbush to respond to that court order. And since then, it's pretty much been, all the mistakes within that initial filing have been corrected.
All right. We've got to take a break. If you can hang here for a few minutes and you want to take some calls?
Sure.
Yeah, if you have a question or a comment, 530-221-1402, and we're talking with District 2, I don't know if I call you candidate, possible candidate for a runoff, Laura Hobbs, and we'll be back. Freedom in Action. Welcome back to Freedom in Action, and happy Father's Day weekend. And if you have a question for Laura Hobbs on the case we're talking about, it's 530-221-1402. Before we go to the phone, I wanted to ask you, have there been other cases that you're aware of that have been similar to this?
Yes, there have been so far. And actually, that's part of what I used initially because I was filing it pro se. I was looking at previous case law to try to model it off of that.
And the plaintiff, they came out winners on that?
Yes, they sure did.
Okay, well, that sounds pretty good in your favor. And let's go to Stones. Good morning.
Hey, good morning. I guess more of a quick comment than anything. It also happened in court in the last few days is not only the admission of the randomized alphabet being applied incorrectly, if at all, other admissions about lack of training, lack of supervision. It's actually very damning. Maybe someday the transcript will get released for public review, but this isn't rocket science. We already have an election in November. There's already ballots going to be printed and ordered, so we're simply asking for an additional race, we'll call it a re-race, to be added to this already very expensive ballot. And if the people that think Mr. Long legitimately was victorious in March, what do they have to worry about? In their eyes, he should win again, correct? So what is the harm in a re-race in order to rectify the now admitted problems in this past election? So that's a quick comment. I appreciate it. Thanks.
All right. Thanks, Stones. That's a good question. Has Mr. Long taken the stand at all, or?
No, he hasn't.
I wondered what his position would be.
Yeah, I don't think that he can really speak to any of the allegations directly, since he wasn't involved in the election process.
Even though, as you said, you had to name him as a defendant.
Though he has commented to local news media that he didn't believe the case had merits. He made that comment just 2 days after the case was filed. So he clearly knew there was a case filed, and that's why he was evading service. Okay.
Well, let's talk a little bit about some of the testimony that did take place. Francesca has, I know she was on the stand for a while, and so maybe you could talk about that.
Sure, I'd love to. So Joanna Francesca testified that they used a hand-counted test deck to test to see if the machine counted the ballots accurately before conducting the election. It's called a logic and accuracy test. This didn't surprise me because hand counting is the gold standard for accuracy. She then described a machine error that was only caught because they did a 1% canvass after the machine tally. A batch of 100 was scanned, but the computer said the batch only had 98 ballots. And Joanna then admitted that they did not keep records of the number of ballots in each batch before scanning them.
Well, that doesn't make sense.
Yeah, it seems like an important record to have.
Yeah.
But she did say that ultimately, if it's 2 or 3 ballots that are off, and this is a direct quote, ultimately, if it's 2 or 3 that were off, we are going to utilize the machine count, and that the machine count is more accurate. And then asked what is the county's threshold for determining whether a discrepancy between the manual tally and the machine tally is worth investigating. Joanna answered, there is no threshold when there's discrepancies. So now remember, she had already established that the hand count was used to determine the accuracy of the machine, and the logic and accuracy testing. And now she says that a discrepancy of 2 or 3 ballots per batch is acceptable. And between the hand count and the machine count, there should be no discrepancy.
No, it shouldn't be.
And if you extrapolate that out for District 2, we had 11,731 ballots. You have about 100 ballots per batch. So if you have 2 to 3 errors per batch, and that's 117 batches, that could equal out to between 200 and 350 ballots that potentially could have gone uncounted. So now remember, this race was decided by only 14 votes.
Yeah.
And one of the hurdles that we had was that the judge would not allow many of the documents I had as evidence into evidence, because they were Excel documents that were over 20,000 pages. One was 20,000, the other one was 90,000 pages. And these are data files that I was given by the county, by the elections office and the county council. But because they were so large that we couldn't possibly print out 20 pages and ask it to be added to the record, the judge would not admit it to be part of evidence.
What did those documents say? Or what were you hoping they would prove?
Well, one of the documents is the ballot tracks data, or the vote-by-mail ballot tracking. It's something that candidates can order, and it tells you how many ballots were received, what date they were received, by what method they were submitted, vote-by-mail, drop box, and whether that ballot was good or if it was challenged or undeliverable. So that's it's part of the voter roll data. It's something the candidate pays $40 for. Most candidates buy these at a regular frequency to see how the votes are coming in. You can't tell how people voted, but you can see, Democrat, Republican,
right,
stuff like that. And so I did order this document, and I ordered it after the election was certified. In this election, we had 54,696 votes total. But if you look at this data, we only had 54,454 voters who voted according to the ballot tracks data. So that means there's about 500 votes that were submitted that were not attached to any specific voter in the voter roll.
Okay.
And in my district, District 2, we have 167 more votes than we had voters.
Huh. How does that work?
Yeah, so these would be, in my opinion, illegitimate votes.
Yeah. So are you asking, well, you can't because he didn't accept that, right?
Yeah, so we have some hurdles there. There still may be opportunities to overcome those hurdles, but the problem is that we have to prove that there was at least 14 votes difference, but yet the evidence we have that would prove that so far has not been admitted into the court.
Okay. Initially, right after the election, didn't you ask for a recount?
Yes, I did, and that kind of gets to the same problem as when I mentioned that they don't keep records of the number of ballots per batch, because if I were to have gone forward with the hand recount, the list that they would have used to conduct the count would be the machine-generated list.
Okay.
It wouldn't have been the manual hand count, because they didn't keep a list for that.
And the reason you decided not to move forward with that was because of the cost, right?
Actually, no, it's more because of the specifics. We couldn't come to mutually agreeable terms.
Oh,
one of the terms I asked for was that the count would be conducted all on one floor, and that the uncounted ballots would be in one stack, and we would go through the stack and make sure we had all the batches and all the number of ballots per batch. Before we even started counting, we would just agree on that, the first starting point. And then as the ballots in the batches were counted, they would be moved to the other side of the room, and the finished ballots would get bigger and bigger. The counted ballot, or the initial original ballots, would get smaller and smaller, and we would see that every single ballot for District 2 was counted. She wanted to do a ballot library system in which ballots were checked out and taken into the bat cave and then taken back and taken, going upstairs and downstairs. And I just wanted it all on one plate, all on one floor, completely transparent and open.
Well, that sounds reasonable, but...
And one other thing, too, on that, since people have harped on this quite a bit, is that I wanted the parties from each side to be able to mutually agree on the intent of the voter on each ballot. So one Republican or one, let's say, somebody from the Hobbs campaign, somebody from Long's campaign, both of them saying, yep, that voter voted for Hobbs,
right,
or that voter voted for Long, and then counting it. But the way that the elections office planned and intended to do it was not that way.
Is it possible? I know you're just asking the judge to pretty much say, yeah, we can have a runoff in November. Is it possible the judge could order a recount of the original votes? I mean, would that be satisfactory to you?
It's possible. At this point, I'm not asking for that remedy because the ballots have been handled. They haven't been stored away in custody such that we know they weren't tampered with. And that was one of my initial requests, was a temporary restraining order to ensure that the ballots would be maintained in such a way that they could be used as evidence in the court. But that was also not addressed in a timely manner. So
okay. We're just about out of time here. So again, if somebody wants to help or contact you or just get some information on what you're trying to do, how do they do that?
They can go to my website for one, which is votelaurahobbs.com, LauraHobbs, and they can donate at lexrec.org/donate. And you can also donate on my website that I just mentioned.
All right. Well, yeah, maybe we'll see you on a runoff in November, and we'll see what the judge decides. Thanks for coming in. I'm glad you contacted me. Good to have this information. So that's it for this week, Patriots. And we'll see you back here again next week. Until then, freedom in action.